All right, guys, we're going to get started. Thank you for coming out today. My name is Christopher West. I'm the president of the Federalist Society here at South Texas College of Law. Before we begin, I'd like to start by reading our mission statement. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to fostering balance and open debate about the fundamental principles of freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. So today's event is Supreme Court Roundup. It's a very cool event where the people in front of you are going to be talking about some of the biggest cases that came out of the Supreme Court in its most recent term. Joining me are Professor Kelso, constitutional law professor here, and Josh Blackman on the far end. Sorry. And then our guest is Mr. Ilya Shapiro. Mr. Shapiro is a senior fellow in constitutional studies at the Cato Institute and editor-in-chief of the Cato Supreme Court Review. Cato is a public policy research organization dedicated to the principles of individual liberty, limited government, free markets, and peace. Its scholars and analysts conduct independent, nonpartisan research on a variety of public issues. He has contributed to a variety of academic, popular, and professional publications, including the Wall Street Journal and the Harvard Journal of Law and Public Policy. He has also been on any of the big networks that you can think of, CNN, Comedy Central being on the and the Colbert Report. He's testified before Congress and state legislators. He's filed more than 150 amicus briefs in the Supreme Court for various parties. And in 2015, the National Law Journal named him to the list of 40 rising stars in the legal community. He's been back here many times. It's always my pleasure to introduce him. So, without further ado, I'll toss it over to our guest. Thank you.
I guess I'll just sit since we're podium sort of out of the way anyway, walking.
I can root you this way.
Sure, well, you're going to be doing that anyway. I should project that Three Amigos thing up here. That's a good right. Well, look, thanks for having me back again. Josh Blackman and I are kind of partners in crime in a host of projects over the years, law review articles, briefs, and a traveling roadshow. So you'll get a little bit of a taste of that. I was a student not too long ago, although I guess every fall my student years go back, recede farther into the distance. And so I recognize that primarily you're here for the free non-pizza lunch, and secondarily perhaps to ingratiate yourself with Professor Kelso, Professor Blackman, and I'm happy to kind of provide your dining entertainment as a tertiary reason. Well, let's dive right in. Last term, after several back-to-back-to-back terms of the century, as it were, was supposed to be give a bit of a breather to those of us who follow the Supreme Court for a living. But that all changed when same-sex marriage and Robert's care came back onto the justices.
That's Obamacare for those who haven't initiated.
Josh will get into that. Looking back on the term, there are several trends that we can discern. Fewer unanimous rulings than in previous years, more results that experts classify as liberal rather than conservative, although that's largely a function of the docket. Next term, when we have more conservative results, it doesn't mean that the justices all of a sudden change their minds. And the lockstep voting of the liberal bloc versus the inscrutability of Justices Roberts and Kennedy. After a term that saw a record level of unanimity, the previous term, the 2014-2015 term actually regressed to the mean. 30 of the 74 cases decided on the merits at just over 40% were unanimous. That seems like quite a decline from the previous terms, 2/3, 66%, but it's that term that was a real outlier. Generally, if you take a 5-year, 10-year, 15-year average, about 35 to 50% of cases are decided unanimously. And recall that the superficial harmony of the previous term papered over real doctrinal differences. And so many narrow rulings produced strident concurrences that were dissents in all but name, especially from the fiery pen of Justice Scalia, who only turned up the heat this term.
Scalia had the most dissents in nearly 30 years, by the way. This is a lot of them.
That's not true. Thomas had more dissents than
For him, no, that's Scalia's by himself.
Okay. Well, the other thing is that the last week of term I was there on the marble steps of the courthouse doing some consulting for CBS News, and it seemed like every case had a writing by Scalia, either the majority opinion, the lead dissent, some memorable concurrence, and so it really was. I mean, that last month, I think, his clerk probably never slept. But anyhow, you get the impression that the court is schizophrenic. Really, to extend that analogy, it's more bipolar. So there's all these unanimous rulings, about half of them are nearly unanimous, and then you have a significant number that are 5-4. Hopeless splits this year on issues including same-sex marriage, of course, but also environmental regulation, death penalty, campaign finance. We can go on, and that doesn't even include the Affordable Care Act case, what I call Roberts Care, King v. Burwell, which was 6-3. As I said, Thomas had the most dissents and the most writing, the most opinions overall. He was the hardest worker of the term, producing 432 pages of opinions, more than tripling Justice Ginsburg, about 143. Now, none of these statistics, which you can look up, by the way, on SCOTUS blog, I didn't even have to have my interns put this together, it's all right there on SCOTUS blog. None of this is really remarkable, generally falling within modern norms. What is remarkable, however, is which justices were in the majority. Now, you can expect Kennedy, the swing vote, to always be the most often in the majority, and he has been over the last 5-10 years, since you can easily track these things. But he fell to third this term. And Roberts, kind of the conciliator, tries to get more narrow rulings with more people joining. He was often second to Kennedy and tying him for first a couple of times in the last 6 years. He dropped all the way to 6th place. So who took their spots?
You'll never guess.
Surprisingly, it was Breyer and Sotomayor at 92% and 89% respectively in the majority. Now, Kennedy still maintained his typical lead in those 5-4 cases, being the majority of 14 of the 19, 8 times with the liberals, 5 times with the conservatives, and once in a heterodox split. But even here, Breyer tied him, and Sotomayor was only 1 case behind. More big news comes out of an examination of judicial agreement rates, who agrees with each other. In past terms, it's typically some conservative pairing, say Scalia and Thomas. But this year, the top 6 pairs were all from that liberal bloc, and the top 3 all involved Justice Breyer, agreeing with each of his liberal colleagues 94.4% of the time. So he was the most unlikely Mr. Congeniality this term. All right, statistics aside, again, you can go on SCOTUS blog, look up, there's like 60 pages of this stuff. You can look at who spoke the most, all these really interesting things that'll make you really popular at your bar reviews and keg parties and things like that. The term was obviously overshadowed by 2 big cases, one of which I'll talk about at the end of my discussion, one of which Josh will cover. But first, before you get to that dessert, you have to go through your veggies. So let's start with the term's fishy case, literally. You might recall a couple of terms ago, or you might have heard about it, there was a case where a woman had found out, this is kind of a typical case of adultery, federalism, and chemical weapons. This woman found out that her next-door neighbor and best friend had been cheating on her, had been having an affair with her husband. And so what did she do? She took some chemicals, some of which she got on Amazon.com, sprinkled them on her car door handle, her mailbox, her doorknob, these sorts of things, producing a minor chemical burn that was quickly washed off, nothing serious. Was she prosecuted for assault or attempted murder? No. She was hauled into federal court for violating the statute that implements the International Convention on Chemical Weapons. Anyway, that ended up being tossed unanimously by the Supreme Court on federalism grounds. But that prosecutor, it turns out, was transferred from Philadelphia, where this United States versus Bond took place, down to the Gulf Coast of Florida, to the case of Yates versus United States, where you have a commercial fisherman catching grouper in the Gulf. He was, during a routine Fish and Wildlife Service inspection, it was discovered that he had caught undersized grouper. Right? We don't want fishermen catching baby fish because that depletes the stocks, right? So that violates the Fish and Wildlife Code, both state and federal. By the time he got back to shore, where they were going to process his citation, there was no more evidence of the undersized grouper.
Where did he go?
presumably had been thrown overboard. So, does that mean a further citation, a higher fine, what have you? Well, probably. But also, he was prosecuted in federal court for violating Sarbanes-Oxley, which is the massive piece of federal legislation passed in 2002 after the accounting financial scandals of the late 90s, early 2000s.
Enron, right over there.
Enron, here in Houston, right? WorldCom, all of these sorts of things. And specifically, there was a provision that makes it a crime for someone who, quote, knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede or obstruct any investigation. So the issue here is tangible object. Is the fish a tangible object? Being prosecuted as a fish is a tangible object, and he was mutilating, destroying, etc., impeding investigation. The court split 5-4, an unusual alignment of justices to toss this conviction. Justice
No
Ginsburg,
pun intended, toss.
right? Justice Ginsburg for this majority. There was something that smelled about this prosecution. She said that tangible object does not refer to any tangible object, but specifically to the subset used to record or preserve information, logbooks, hard drives, that sort of thing. Justice Alito concurred, put a finer point on it. Quote, although the language of Section 1519 could apply to nouns as far-flung as salamanders, satellites, or sand dunes, the last phrase in the list, makes a false entry in, makes no sense outside of file keeping. How does one make a false entry in a fish? In dissent, that law and order conservative Justice Kagan said, tangible object is tangible object. If you don't like that, Congress can fix the statute. Now, lots of people were saying, well, this is kind of forecasting how the justices are going to line on King v. Burwell. Exchange established by the state. Does that really mean an exchange established by the state? How do we interpret the text? These sorts of things. Those who were trying to pick up on any clues from this Yates case to that were sorely
This never works. Never.
No.
It never works.
So anyway, that was the fishy case. From there, we will move on to what would have been the blockbuster of the term had it not been for gay marriage and Obamacare, and that comes from Texas. It involves the application of disparate impact theories to the Fair Housing Act. The name of the case is Texas Department of Housing versus the Inclusive Communities Project. Now, under civil rights law generally, employment discrimination, public accommodations, other civil rights laws, you can violate the law and be subject to civil or potentially criminal liability, not simply if you discriminate on the basis of race or sex or other protected classes, but even if you have a neutral policy or rule or action by the state or a private party enforcing a state program, if it has what's called a disparate impact on a protected class for no good business or public policy reason. And here we have at issue a Texas program that allocates federal housing tax credits to developers who build low-income housing. In this particular case, this was out of Dallas, the developer was putting a lot of units in kind of the cheaper parts of town, which were disproportionately occupied or people who lived there were disproportionately racial minority. A group called the Inclusive Communities Project, which tries to place low-income tenants in predominantly white suburban neighborhoods, sued, saying that this, even though there was no racially discriminatory motive, this neutral policy, they wanted to create more housing units, had a disparate impact. Now, every lower court, every federal appellate court to consider the issue had allowed disparate impact claims. I believe there were 9 circuit courts that had ruled, even though the text of the Fair Housing Act is silent on this, and Congress, when it's amended it over the years, didn't outlaw it or allow it altogether, so that the text is completely silent. Twice in the previous 4 years, the Supreme Court has tried to take up this issue, but the federal government, the administration, has forced settlements. Clearly, the Obama administration did not want this Supreme Court to decide this issue. And for good reason, based on oral argument. This is, again, why you try not to predict things based on oral argument, because it seemed like there were 4 clear votes against the cognizability of disparate impact claims under the Fair Housing Act. And the swing vote was an unlikely one, Scalia, who probably saw that the legislation allowed disparate impact claims, but that made the legislation unconstitutional. So probably the Texas would win, and the developers would be allowed to continue their program. But a funny thing happened on the way to June, and in this case, by the way, came out the same day that Obamacare came down, so it was lost in the
It
shuffle.
was a bad day.
Justice Kennedy, writing for the majority, and like he does in a lot of cases involving racial preferences and racial claims, affirmative action, not least, doesn't necessarily like this particular claim, but keeps the door open, does not close the door on these sorts of theories. So arguably, he tightened the requirements that lawyers have to prove in court to make out a disparate impact claim. Gave a lot of good language to defense counsel, including in this case, showing that even if the burden shifts to the developer or the state agency, once there's a prima facie case made out of having this disparate impact, they can very clearly say, look, we have a good reason for doing so. And for example, here, the reason is they want to build a lot of housing units. And obviously in the cheaper part of town, you can get more real estate, you can build more than in the more expensive, whiter parts of town. Justice Thomas makes this point in a really excellent dissent. I encourage you, Justice Alito in the main dissent takes issue and kind of grapples directly with Kennedy's statutory interpretation. That's well enough for black letter law, but I think Thomas really gets to what's underlying the issues here. He says, that error will take its toll. The recent experience of the Houston Housing Authority illustrates some of the many costs of disparate impact liability. The authority, which provides affordable housing to low-income residents of Houston, has over 43,000 families on its waiting list. The overwhelming majority are black, because Houston is a majority-minority city with minority concentrations in all but the most affluent areas. Any developments built outside those areas will increase the concentration of racial minorities. Unsurprisingly, the threat of disparate impact suits based on these concentrations has hindered the housing authority's efforts to provide affordable housing. State and federal agencies have refused to approve all but 2 of the agency's proposed development projects over the last 2 years out of fears of disparate impact development. That the majority believes that these are not dire consequences is cold comfort for those who actually need a home. And so developers and housing agencies effectively now face a suit if you do, suit if you don't situation. Stay tuned. Lawyer Full Employment Act. If you go into housing law, plaintiffs or defense side, I think this is a good ruling for you. The next case is one of the most bizarre ones in the term, at least because for the first time ever, the Cato Institute, big libertarian think tank, filed a brief supporting the federal government, first time in history. Case is North Carolina Board of Dental Examiners versus FTC. And it's one of the few exciting antitrust cases you might encounter. There's a doctrine called Parker immunity, which says that if a state is acting, or a private actor at the behest or control or permission of the state, they are immune from antitrust liability for behavior like colluding with competitors or monopolization, these sorts of things under which you can be liable under the Sherman Act or the Clayton Act, the big antitrust laws. Well, here we have a situation where a group of dentists who control the Board of Dental Examiners started sending cease and desist orders to hygienists, pharmacists, cosmeticians, people who were performing the very dangerous procedure called teeth whitening. Now, this is so dangerous that you can go down to your local Walgreens or CVS, whatever the drugstore chain is here, buy a kit and do it in the privacy of your own home. But they didn't want any competition from unlicensed dentists doing this. There were no consumer complaints, by the way. And they said they were sued by the federal government, by the Federal Trade Commission, who, along with the Justice Department, looks after the antitrust laws. And they said, look, we have this Parker state action immunity. We're the North Carolina Board of Dental Examiners. And the court said, well, that's not good enough. There's not even a patent of state control or supervision here. There's not even some deputy undersecretary of health here who's on the board to rubber stamp its decisions. Purely self-interested dentists, you don't get the immunity. So that's kind of good. It tightened this immunity, although there are a lot of, it could have gone further. I have an article coming out in the NYU Journal of Law and Liberty if you're interested in this case or how antitrust law intersects with state action. You can look that up, fairly short article. But this is interesting because it's sort of the flip side of the sort of libertarian public interest lawsuits against occupational licensing. You hear the troubles with Uber, Airbnb, these sorts of regulations. Upstart entrepreneurs come into conflict with established cartel-like regimes. Maybe antitrust law is the way to go. And already we're seeing an effect from this case. Oklahoma, for example, their AG, their Attorney General, about a month after the case came down, issued an opinion letter to the governor saying, review all of your executive agencies to make sure they're actually state control, lest we be subject to the same sort of violation. And finally, same-sex marriage. Burwell versus Hodges, obviously everyone knows. By a vote of 5 to 4, the court required all states to issue marriage licenses to same-sex couples. A few words on the consequences of the ruling. Just because it was expected doesn't make it any less momentous. In sometimes soaring rhetoric, Justice Kennedy for the majority explained that the 14th Amendment's guarantee of both liberty and equality means there's no valid reason to deny this institution the benefit of these particular laws to same-sex couples. Good enough. But the only good thing that can be said about Justice Kennedy's opinion, from my perspective, is that he somehow arrived at the correct result. I've reread the ruling several times. I guess you will have to do that in your con law class.
Coming soon.
And I've concluded that it gives me a headache and it's not a judicial opinion. What should have been a really easy case about equality under the law, Cato filed a brief explaining how an originalist understanding of the Equal Protection Clause and what it means for state licensing regimes it makes this an easy case, just like those occupational licensing laws. This isn't really a case about the definition of marriage, it's another licensing case. Like, for example, a state has good reason to deny blind people driver's licenses, probably doesn't have a good reason to deny them business licenses. Same sort of thing here with respect to same-sex versus opposite-sex couples and drawing marriage licensing regimes. Of course, I don't see a reason why marriage should be licensed in the first place, but that's a separate discussion. Instead, Kennedy tried to write for the ages, but rather than making this kind of historic statement about the equality of gay and lesbian Americans, he produced a meditation on how the Constitution protects, quote, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity. I have no idea what that means. As far as I can tell, the rule is you take a cup of due process, a scoop of equal protection, mix them together, sprinkle on some equal dignity, tie it in a poetic bow, and voila. That's not law, ladies and gentlemen. It's not the due process clause or substantive due process that provides the rule of decision here, or should. And that's not because substantive due process has no substantive content, or due process clause has no substantive content, like a lot of conservatives might say. You can't have like a duly authorized, well-functioning kangaroo court, like a Stalin show trial, and say that you're lawfully being deprived of your life and liberty. It has to be some substantive due process of the law. But here, it's the Equal Protection Clause that's at issue. Justice Thomas does well in his dissent to show Kennedy's confusion about what a fundamental right is. It's not like in the state of nature, we're born with lots of inalienable rights, including the right to get a piece of paper from the government. Right? That makes no sense. This is about how the state draws its lines, not what kind of fundamental rights we have. This is about state recognition of marriage, not about the right to live together or hold yourself out as a couple. This isn't Lawrence versus Texas criminalizing sodomy, or even Loving versus Virginia, which criminalized interracial cohabitation, not just made it impossible to get a marriage license. Moreover, Kennedy filled his opinion with verbiage about how marriage, quote, has promised nobility and dignity to all persons, and that denying it would, quote, disparage their choices and diminish their personhood. So apparently those of you who are single, Kennedy doesn't feel that you're fully fulfilled as human beings, and Justice Roberts notes that there's no nobility and dignity clause in the Constitution.
We can't get titles of nobility, though.
What's that?
We can't get titles of nobility.
We can't accept titles of them. So I suppose that prohibits, anyway. That's
Marriage title of nobility is unconstitutional.
But where do we go from here? And I'll end with this. What about people who disagree in good faith, quite literally, with no ill intent towards gay people? Well, ministers, to the extent they play a dual role in signing state marriage licenses, now have to officiate big gay weddings or lose their ability to sign those licenses? Will bakers and photographers, all the wedding vendor cases, have to work them? What about employment discrimination protections based on sexual orientation? About half the states have them. Is that now going to be constitutionally required? Perhaps not, because Kennedy's rule doesn't have any rule of decision. As I said, maybe if he had drawn some sort of equal protection law, that could have been used as precedent in these other cases. I have no idea. It's really unclear. I mean, I can tell you what my view is and how the law is or should be, but it all depends on whether Kennedy remains on the court to answer these questions in his own hand-waving way. But all of these examples, including marriage licensing itself, show the folly of government insinuation into the sea of liberty on which we're supposed to sail our ship of life. If government didn't get involved in regulating private relationships in the first place, then we wouldn't be in this second-best world of adjudicating competing rights claims. But that live and let live world is rapidly contracting, so we're forced to fight for carve-outs of liberty among a sea of mandates, regulations, and other authoritarian nudges. So in any event, good for the court, and I join with Kennedy in his hope that both sides now respect each other's liberties and the rule of law. But the actual ruling that got us there could have been a lot more. I stand ready to defend anybody's right to offend or otherwise live his or her life in a way that I might not
Okay, I've been delegated the task to speak on the free speech cases from the last term, and there are 4 cases I'm going to talk about. They all share, I think, one interesting feature, which is that the decisions themselves seem to me to be, from my perspective, exactly right. And even if you don't agree with them, they're not major impact really much anyway. But in each of them, the way the court went about defending the result, the majority, sort of their logic in their opinion, I think is going to cause some problems later on in terms of free speech doctrine. So I'm going to talk about the 4 of them, and each one, the decision itself isn't all that big a deal. But the possibility that some of the language in the opinion may come back to haunt in later cases, I think that's the real thing to watch as we go forward. Okay, the first one of these is Reed v. Town of Gilbert. And in the Reed case, it involved a city that had a sign code regulation. You put up certain signs of different sizes for different lengths of times in the city. And the city sort of had a really, they didn't even explain particularly why they drew the distinctions they drew, but they had different rules if you had an ideological sign that conveyed an ideological message, or if it was a political sign that was related to a political campaign, or if it was just a directional sign saying, here's an event, and here's the sign pointing you with an arrow toward the event. And they allowed sort of ideological signs to be up there really as long as you wanted, and no time restriction on those. For the political signs, they said they can only be up during an election season, and they had a definition of what the election season was. But for directional signs, they said you could only have them up 12 hours before to 1 hour after your event. So you couldn't advertise the directional sign to your event except 12 hours before it's going to happen. Okay. And naturally, people who had events going on want to advertise more than 12 hours before the event. They want to have the sign up there, maybe days in advance. And if it had been a political sign, it could have been up there days in advance. Had it been an ideological sign, it could have been up there days in advance. But not the temporary directional sign. Okay, the court unanimously strikes that down as unconstitutional. The city provided no explanation for these distinctions between these different categories of signs. But the normal doctrine before the Reed case would have been, well, maybe the city's got some plausible content-neutral reason in terms of aesthetics or cluttering too many signs out there, distracting drivers if there are too many signs or whatever. And so you would have applied intermediate review, because for content-neutral regulations of speech, you apply intermediate review. You still would have struck this one down, because even under intermediate review, it's got to be substantially related to some substantial government interest, and the government didn't have any real explanation for it. So even under intermediate review, you strike it down, which is what 3 of the liberals in a concurrence said. That, we can just strike it down under intermediate review. We don't need to change anything about free speech doctrine. For the majority opinion, said, we're going to adopt a little different approach to thinking about these free speech cases. They said if the regulation on its face is based on content, even if you've got a content-neutral reason for doing it, like aesthetics or sign clutter or whatever, if the regulation on its face uses a content distinction, like we're drawing distinctions between ideological, political, or directional signs, that's a content-based distinction, you're going to apply strict scrutiny for content-based regulations of speech. Which means, if you take the opinion seriously, in the future, any government regulation that has a content based on its face distinction is going to trigger strict scrutiny, not intermediate review. And that can be a problem. For example, lots of cities have regulations of adult motion picture theaters or adult bookstores. And historically, those regulations have been upheld under intermediate review on the grounds that you've got a content-neutral reason for regulating adult motion picture theaters because when you've got those theaters around, they affect neighboring property values. You tend to have greater prostitution and drug dealing around such adult motion picture theaters. So you're worried about the secondary effects of those theaters. So you've got a lot of content-neutral reasons of harms those theaters cause without regard to the content of the movies they're showing. And typically the court in the past has upheld then cities regulating, saying zoning laws, you've got to keep your adult motion picture theaters X number of feet away from schools, from residential neighborhoods, from churches. Now, of course, you got an adult motion picture theater you're trying to regulate, or adult bookstore, and you're regulating it. You're regulating it because it's an adult theater or an adult bookstore. It's the content of it. Those regulations are now going to have to satisfy strict scrutiny, and strict scrutiny, of course, is difficult to satisfy. You got to show the government has no less restrictive alternative to regulate than the way they chose it, which is going to mean I think cities are going to have a little more difficult time justifying their zoning ordinances for such establishments. Another case, sort of a good example, a city had an ordinance trying to limit the number of, when people are standing on intersections and trying to panhandle for money. Their ordinance said you can have a sign there saying, I want money, and if somebody wants to give you money, okay, but you can't make a spoken request. You can't go up to a car and ask the person for money on the grounds that that's sort of is a little more intrusive, it's a little more coercive, and it's going to sort of slow down traffic even more than it might otherwise slow it down. Under intermediate review, a court of appeals upheld such an ordinance, saying, yeah, the city's got substantial interest in worrying about people coming up to you while you're parked at sitting at a red light at an intersection and trying to talk with you into giving them funds. It's one thing if they can hold a sign up and just if you roll down your window, you give them funds, okay. But they don't want people coming up talking to you. After Reed, the Court of Appeals reheard the case and said, well, now after Reed, it's got to be strict scrutiny because you're regulating the person saying they can't talk to you, they can just hold up a sign. That's a content-based distinction. Signs are okay, talking isn't. And under strict scrutiny, the Court of Appeals said, you can't do that anymore. You can't have that regulation. The panhandler has the equal right to come up and sort of talk with you, try to yell at you through your window to try to get funds. To me, that's a little troubling. I mean, for others, not troubling. But we'll see. I'm not confident the court actually will apply this Reed test when they get cases involving adult bookstores or adult motion picture theaters or a panhandler case. But the logic of their majority opinion seems to indicate they will. So that's one of the things we'll sort of see in the future. Have they made it more difficult for cities to regulate in areas where it seems like reasonable zoning ordinances might be appropriate? Okay, the second case, Walker v. Texas Division Sons of Confederate Veterans. This was the case where individual wanted to have on their license plate, especially license plate, having the Confederate battle flag. And the state of Texas said, no, we're not going to do that. We've got a lot of other things you can have specialty license plates about. You can say you're UT graduate, you can say you're a Texas Aggie or a Baylor Bear.
Dr. Pepper.
You can say Dr. Pepper. You can say lots of things on license plates. They got about 300 specialty license plates to let you do. But Texas said, no Confederate battle flag. Now, here's that Constitution. The individuals challenged it saying, you're engaged in viewpoint discrimination. You're letting these other signs be on license plates, but not my sign because you disapprove of my use of the Confederate battle flag. And so that was their free speech argument.
I filed a brief, by the way, with PG O'Rourke saying that the DMV of all agencies should not be deciding what's offensive.
Exactly. But the Court 5-4 in the case said, no, they think license plates really are government speech. They're not sort of an individual expressing their own message on their licensing plate on the government's license plate, which would be normally how you would have thought about it. You would have thought license plates are non-public forms, they're owned by the government, but people have a limited right to express which license plate they want, which special license plate they want. That's what you would have thought before this case. But this case said, no, the whole license plates and the whole, what license plates are approved, it's all government speech. And if it's government speech, the government can engage in viewpoint discrimination. They can pick messages they favor or not. Now, this was one of these 5-4 cases that was really unusual. It was the 4 liberals standing up for the government. That's not surprising. But then it was Justice Thomas who joined them in this case. It wasn't a Kennedy joining the liberals or Roberts joining the liberals. This was Thomas joining the liberals. But to say that the license plate is just pure government speech. The problem you're going to have with that is, well, in the individual case, to me, it's not so bad. Confederate battle flag is sort of an offensive symbol. I'm not all that more worried about it. It's not a big deal that you can't have a specialty license plate. You can still put up a bumper sticker on your car with the Confederate battle flag. That's perfectly constitutional. So if you want to have on the back of your car the Confederate battle flag, you can do it. It's just going to have to be on a bumper sticker, not the license plate.
Or on your roof.
Or on your roof.
That might be hazardous, though.
You can do it. So again, it's not a big result in the individual case in terms of people being able to express, messages.
We can do that later.
But it does mean governments now, in their specialty license plate decisions, can engage in blatant viewpoint discrimination, and you've got no complaint. And of course, the big issue that most of these cases have involved have been either pro-life or pro-choice license plates. And most courts before reason had said, well, you can't engage in discrimination. If a state is going to have a license, specialty license plate allowing, saying, I'm pro-choice, they also have to allow one saying pro-life, or the other way. You've got to have sort of equally, both sides, if you're going to have a license plate, have to be able to have a license plate on their side of the debate. After this case, a state could say, no, we're just gonna have a license plate on one side of that debate, and you can't challenge it. And so, a liberal state like California might say, we only want pro-choice license plates in our state, and a conservative red state may say, no, we're only going to have pro-life plates. And to me, that is a bad result. It's just a bad result to let the government make that kind of viewpoint discrimination and not have it be subject to any sort of First Amendment free speech review. But that's the result because, in this case, was Thomas joined with the liberals to do that.
Even worse, in Texas, we have lots of, it's not just Aggies and UT or Baylor or whatever, you have University of Oklahoma plates, Stanford, Duke. I mean, the Aggies and the Longhorns might be offended by each other, but both of them are offended by the Sooners, right? Here it's the Texas government that's apparently endorsing speaking in favor of the Sooners. It's just a bizarre world.
Well, and particularly, it's now, after this case, Texas could authorize whichever of those plates sits once and not the other one. They could say, we're going to have UT Austin plates, we're going to have Longhorn plates, but we're not going to have Texas Aggie plates. And you couldn't challenge them.
And they go to Civil War, Randy.
Well, I know. They were likely politically not to do that. But the point is they could. Constitutionally, they can now do anything they want with license plates. So I say,
you know who the first casualty of this ruling is? I don't know if you saw this. The Redskins, Washington Redskins.
Yeah.
A month after this ruling, the district court deregistered the Redskins' trademarks. Not because of offensive under trademark law, but because trademarks are government speech. It's bizarre. It's not on appeal to the federal circuit, which could affirm on other grounds, but it shows kind of the mischievousness of this ruling.
Yeah, again, the particular case, you put up a bumper sticker with your Confederate battle flag if you want, but it's kind of a mischief justification. And you didn't have to do that. If you wanted to uphold what Texas was doing, you could have done it under traditional law and just said, under strict scrutiny, viewpoint discrimination, we think that Texas, there's a compelling government interest in not having the Confederate battle flag, which was a symbol of rebellion and treason and racism and slavery. You could have said there's a compelling interest there under strict scrutiny, but kept the strict scrutiny standard to deal with all these other cases where you don't want the government making viewpoint discrimination distinctions. You could have done it on that narrower ground, but they didn't. So again, it's one of those cases where the result's not bad, but it's sort of a mischievous justification, which might. Okay, the third one, the Alonis case. Now, this case actually wasn't a constitutional case. It was a statutory case about a person making a threat, one of these internet threat cases. And in this case, it was a couple estranged, and so it's the husband, threatening the wife and others online.
Allegedly.
Allegedly.
Rap lyrics, too.
Allegedly about murdering his estranged ex-wife, massacring a class of kindergartners, slitting an FBI agent's throat. Okay, and he's prosecuted under the federal statute about making it a crime to put any communication containing a threat to injure another person out there. Okay, the issue is, what do you have to prove in that case to satisfy the statute? Do you have to show just that a reasonable person viewing that would perceive it as a threat when he's got stuff about massacring kids and murdering wives and slitting FBI agents' throats? Or do you have to...
Mind you, he has this written up as sort of a parody or a satire of Eminem's lyrics, which are very similar to what he's actually saying.
Yeah, that's right. He's trying. That is, his argument is, I wasn't threatening anybody. I was engaged in satire. That's his argument. And the question is, in terms of what the standard is to convict him, what do you need to show? Okay, in this particular case, the court interpreting just the statute says, well, since the statute isn't clear, it doesn't say you need to show he had some subjective intent to threaten, or is it enough to show just a reasonable person would feel threatened? The court said, well, typically in criminal law, we sort of have a notion that there has to be some subjective culpable intent. That's sort of the basis of most criminal laws. So the court in this case said, well, we think, looking at this statute, that that if you had subjective intent to threaten, or if you could show he knew his communication would be viewed as a threat. So not that he intended to threaten, but if he knows the communication would be viewed by these other people as a threat, you could convict him. But you got to show one or the other, either subjective intent or he knows his communication will be viewed as threatening. But then they also left open, well, what about reckless disregard? What if you could show that maybe he didn't know it would cause a threat, but he was recklessly disregarded all the facts that would lead him to conclude it would be a threat? Would that be enough? Well, the court left that open. They said, oh, look, worry about that in another case. Okay, now they're going to have to retry this guy now. I mean, originally he was convicted under a standard that just, if a reasonable person would perceive this was a threat, he could be convicted, and he was convicted. And now, presumably, you go back and retry him and have the
He's
evidence.
already been in jail. He might just...
Well, they might let him go. But you could retry him, just try to prove that this kind of language, either he didn't know, he didn't have the intent, or he knew the communication would be viewed by others. Because language like this, he's saying, oh, it was just all an Eminem parody. I didn't intend to harm anybody. But you might say, well, you still sort of know that other people looking at it are going to feel it as a threat. But okay, in the particular case, that's the thing. But it's not a constitutional case under the true threat doctrine. But if you apply the logic of the opinion to the constitutional true threat doctrine and say, what do you have to show to be able to say you can regulate just threats generally as a constitutional matter? And if you adopt the view of this case, that no, it's not enough. Under current doctrine, if you can show a reasonable person would perceive something as a threat, constitutionally, you could prosecute them. Under this case logic, maybe you can't do that anymore. Maybe you've got to show some higher standard of actual subjective intent or know that the other person will perceive it as a threat. And of course, there are lots of threats out there that people make on the internet. It's filled with negative comments and negative threats of all kinds against all sorts of individuals. I think this opinion, if it is applied constitutionally, may make it harder to prosecute a lot of those people who are posting really vile stuff online. And at least that's the concern I have about the case, is it may extend and make it more difficult. Because people think they can just say anything online and they're totally free to say what they want and not have any consequence, even if people are really seriously threatened online and feel emotionally troubled by it. Well, we'll see what happens. We'll see what happens. But again, in the individual case, probably under this statute, with the normal presumption that criminal laws have some subjective intent, it's not a bad decision in terms of this particular statute, this particular case. But it might have, if extended, it might make true threats a little more difficult to prosecute. Okay, the final one, Williams v. ULA, Florida Bar. This is a question about free speech in the context of judicial campaigns, what a judge can do in terms of raising funds in those many, many states where the state court judges are elected. The Florida law said that they didn't want the judge to personally solicit campaign contributions for their election campaign. They thought that would sort of create all sorts of conflict of interest, appearance of corruption. If you're out there, give me money, maybe I'll vote for you, or maybe in a case come before me, I'll decide it in your favor, or in any event, there'd be sort of pressure by pressure by attorneys who practice before that judge to give them some money if they're personally solicited by the judge. And that's, a real concern. If you're an attorney going before a judge, and if that judge personally asks you for money for the campaign, and you say, I don't think so, you're going to want to go before that judge the next time around. It's a little bit, that was the state's concern. They did, of course, allow the judge to set up a campaign committee and have the campaign committee solicit from the attorneys and other people in the community money for the judge's campaign. So the question is, can you just stop personal solicitation? Okay, it was a 5-4 case. This was one where Justice Roberts joined the 4 liberals to support the government's position. Then, yeah, you can stop that. You can say that a judge can't personally solicit campaign contributions. And, of course, the other 4 conservatives in the sense said this is violating the free speech right of the judge. They shouldn't have to go through a campaign committee and have the chair of their campaign committee solicit funds on their behalf. The judge even write a thank you letter. After the campaign committee solicits the funds and gets the funds, the judge can personally write a thank you note. That's
the rule really doesn't do
That's
anything in
right.
the first
Well,
place.
this is the point. The rule should be tested and was tested under strict scrutiny because it is a content-based regulation of speech in political campaigning. Under strict scrutiny, the rule doesn't seem to be very well narrowly tailored. That's exactly that. It doesn't seem to really meet strict scrutiny. It's not a bad result to me, but it doesn't really meet strict scrutiny. And so what you're doing in the case is you're watering down strict scrutiny in order to justify a result. And that has bad implications in other cases if you're watering down what strict scrutiny really means. And clearly you're doing that in the majority opinion to get the result you want. So again, it's another case. I mean, to me, the judge can easily, you don't have to personally solicit. You set up a campaign committee, you put someone, an attorney friend of yours on a chair, that person solicits the funds, you write your thank you notes. I don't think it's going to limit much solicitation and collecting of funds for most judges. But the underlying principle and the fact that you water down strict scrutiny to reach that result, that again is kind of the problem. So in each of these cases, 4 cases, I say, to me, the result is not all that horrible. You can quibble a little bit. But you sort of deal with the result in particular cases. But in all of them, the court seems to be doing things in the logic of their opinions. Sometimes, as with Roberts joining the liberals, sometimes in the Texas license plate case, it was Thomas joining the liberals. They seem to be doing things that are maybe problematic in later cases, and we'll just have to see.
All right, batting cleanup. So I'll stick with one case only, Obamacare. So we had yet another battle. I think every time we hear Ilya, we have another Obamacare case. It feels like deja vu already. So we have this case called King v. Burwell. When the Affordable Care Act was being created, there was a debate. Where will people buy their insurance from? Will they buy it from state-run exchanges or from a single federal-run exchange? And there was a big debate about this. The House representatives wanted a single federal exchange. Members of the Senate wanted state-run exchanges. And there was lots of discussion about how to accomplish this. The long and short of it is, the bill that actually passed the Congress had one very important phrase in it. Subsidies to buy insurance from the exchanges to make your insurance affordable. Subsidies are available on, quote, exchanges established by the state. Okay? Exchanges established by the state. Now, if we're one to just read those few simple words, one would think that subsidies are only available on exchanges established by the state. The Obama administration said that can't possibly be the correct answer, because then the 30-something states that did establish exchange, like Texas, could not get subsidies.
Which was unexpected. The designers wanted states to set up their own exchanges, and they expected all of them to do so, and so we wouldn't have this issue. But funny thing happened on the way to Utopia, and unfortunately it did.
Right. So here's the problem. If subsidies were not available in states like Texas, Obamacare would implode, or to quote my new book, it would unravel very quickly. Because once subsidies are not available, people can't afford insurance, young, healthy people won't buy insurance, the markets will be flooded with old and sick people, implosion, right? Death spiral. So this case goes to the courts, and the courts have to consider, can we read a statute that says subsidies are available in exchanges established by the states to mean subsidies are available in all exchanges, federal or state? Did it again, Ilya. Chief, once again, he did it again, right? He broke my heart. So the Chief Justice acknowledged that the plain text reading of the statute is strong. He admitted that quite candidly. However, he said, if we were to construe the Affordable Care Act to limit subsidies in states that establish exchanges, that would have the effect of effectively destroying the health insurance market. It would render other provisions of the statute, irrelevant. It would make different exchanges worthless. And he was able to read the text in a way that the exchange being established was actually by the federal government, that the federal government steps into the shoes of the state government. Is that the best reading of the statute? Who the heck knows? Is that what Congress...
He says it's not.
No. He says it's not the best reading of the statute, but based on various tools of statutory interpretation, he finds a way to once again save the law. Now,
and that's important. It's by using statutory interpretation. You didn't just defer to the IRS's interpretation.
right. So what's salient here is that the Chief Justice did not just listen to the federal government's interpretation of it. Now, one point I want to stress, at the end of his opinion, the Chief Justice made something very clear. He said, basically, stop. Stop bringing me these Obamacare suits. I do not want any more of these Obamacare suits. Stop trying to destroy this in the courts. Chief Justice Roberts, although he says he's one of judicial restraint, that's hardly a fair characterization, but he says, we do not want these. So what did Ilya and I do? We filed another Obamacare brief about a month ago, asking to destroy Obamacare and the Little Sisters of the Court case.
To be fair, this is kind of Hobby Lobby part 2. But
it would unravel.
Well, somewhat.
Yeah.
Yes.
So effectively, and I'll give a little preview of the upcoming term, one of the biggest cases we'll have this
I'll
year.
note, by the way, in King, Scalia's dissent, I think, is even more interesting because less bitter and more kind of just meaty statutory interpretation in King than it was in dissent in Burwell, and he calls Roberts' opinion interpretive jiggery pokery and applesauce.
Pure applesauce.
Pure applesauce.
Thank you.
Now, if you go to Savannah, Georgia, there's a Moon River Brewing Company. I was there 3 or 4 weeks ago. And one of their seasonal brews is the jiggery pokery. Anyway, I took a picture of this and tweeted it out. It went viral. I think the Federal Society in Washington is going to have a keg of it for their Christmas party. But I recommend it. It's very good.
So what's coming up this term? Okay, this term is a case called, well, we don't have it yet, but it'll involve the contraceptive mandate part 2, if you will, right? So the first one involved the Hobby Lobby Corporation. Can you make a closely held for-profit corporation pay for contraceptives through the insurance plan? Supreme Court said, no, you cannot. The second one involves various religious nonprofits, for example, the Little Sisters of the Poor, Pope Francis had the time to visit them, and we call this symbolic visit. They are not being required to pay for the insurance. Instead, the government offers them what they call an accommodation. The government will pay for these products so long as the insurance contract between the Little Sisters and the insurance company is modified to cover them, right? And the Little Sisters say, because you are making us modify our insurance contract, even if we're not paying for it, that imposes a substantial limit on the Religious Freedom Restoration Act. And the Supreme Court will likely grant
Makes
certiorari.
them complicit in the chain of sin.
Complicit in the chain of sin. Neither of us are Catholic of the Red Masses tonight, so we will go pray for the Little Sisters.
We don't take a theological position on it.
We don't. We have no theological position. Our argument is actually much simpler. We argue that the HHS lacks the authority to make accommodations to Congress and give it to them. It's the question of interpretive authority. The last case I want to talk about very briefly is a case called Zivotofsky v. Kerry. This is also a repeater. We actually studied this in our combo class a couple weeks ago. So, believe it or not, if anyone's ever been to Israel, the American embassy in Israel is in the city of Tel Aviv. It is not the city of Jerusalem. Why? Since the 1950s, the United States has basically taken this weird policy that
The bars are better in Tel Aviv.
the bars are better. Yeah. So the United States has taken this policy that effectively that Israel and Jerusalem is a no man's land. No country owns the city of Jerusalem, right? Contrary to every other indication in the world. So what happens if you're an American citizen born in Jerusalem? What will your passport say? It will say you were born in Jerusalem, not Israel, but Jerusalem. If you're born anywhere else in Tel Aviv, your passport will say Israel. We will not stamp it. So a law was passed by Congress which tells the Secretary of State you are required to stamp passports if someone requests it with Israel. Now, 2 senators voted for that bill, Hillary Clinton and John Kerry.
Well, more than 2 voted for it. But
As relevant to this case,
Yeah.
Secretary of State Clinton and Secretary of State Kerry both argue that this law is unconstitutional. They actually voted for a law they argue was unconstitutional. Go figure, right?
Oy vey.
Believe they, right? Okay. So what happened? The Supreme Court heard it once, asking was this a political question. They said, no, it's not a political question. Went back down. Went up again a second time in a 5-4 decision. That was very sharp, and I'm still on the fence about this one. The Supreme Court held that it would be unconstitutional. That would violate the separation of powers to force the Secretary of State to recognize a foreign country that is the capital of Israel. There was a very vigorous dissent by the Chief Justice saying, no, this is not actually this is not really recognition. This is actually an act of Congress's powers over foreign affairs. Where this case shakes out is not clear. So on the one hand, the president won. But on the other hand, the president had a serious defeat because they said, listen, your powers are not as broad as you think, right? You maybe have exclusive power recognition, but these other spheres, not so much. So this case is serious mixed bag of executive power.
And this law was passed under Clinton, I believe.
Bush.
Under Bush, right. So had this case been brought when Bush was president, would the justices have flipped? Because effectively, this is a win for the Obama administration, sort of. It's kind of a win for the executive in general. So it's weird political overtones. I actually expected it not to be a traditional liberal versus conservative split in some sort of heterodox.
So I'm going to stop here and give you guys some time for questions, which is always our most important part. So thank you so much, and we welcome your questions. Yes, sir.
I'm sorry, I don't know all of your names.
I'm Josh.
Josh,
Ilya.
Ilya, and
Randall.
Randall both. You were talking about the case with the adult video stores and basically monitoring, keeping them out. I'm a little confused as to how the strict scrutiny works, because to me, it doesn't matter what the content is if I can still claim I'm trying to keep the prostitutes out of my area. Like, can't I say I'm not limiting their, or whatever you want to call the extraneous effects of the adult video stores and whatnot. You can say you're not limiting the content, you're limiting the factors that come with it, similar to...
That's what the law was before this Reed case.
Yeah,
And that's exactly, I think, a sensible law. After this Reed case, though, if you take it literally, they're going to say, because you're regulating an adult theater, and only adult theaters, even if you're doing it for all these content-neutral reasons, because you're regulating adult theaters on the face of the statute, it automatically triggers strict scrutiny. It automatically becomes a content-based regulation. And that's why I think it's a bad thing for them to say in the opinion. I think that's a bad result. But if they live up to it, that's what they're saying.
Yeah, I'm already signing some briefs. So the court made absolutely no mention of the secondary effects case at all. I'm actually litigating a case now involving 3D printing guns on the Second Amendment and the First Amendment. And I'm actually relying on this case quite heavily to try and get reversal from the district court. Randy's right, this is going to be a big case. Other questions?
We have time for a few more. Other big cases to watch out for?
In the back?
Thank y'all for being here, by the way, but I was wondering, just a point of clarification on the North Carolina Dental Board case. Were the members of the board, were they appointed by the governor of North Carolina? How did they come to get their seats on the board?
I think they pick their incoming slate, but there is some, yes, state imprimatur, you get some sort of permission or something like that. But the state's involvement is limited to that. They appoint them when they do.
Other questions? Yes, sir.
I know one of the big claims, charges, things that was going to happen from the gay marriage was that every preacher you know is going to be in a lawsuit within a week because he refuses to marry gay couples, and that our churches are all going to be forced to marry gay. How many of those?
That's not the fear. The fear is not that priests will be forced to marry people. That's never the problem, right? As it stands now, if I'm an Orthodox Jewish rabbi, I don't have to marry a Reformed Jewish couple or a gay couple. But the big issue is tax exempt status, and this one I can't harp on enough. During these oral arguments in Burwell, I think the Justice Alito asked, so what about tax exempt status? Can a religious organization who refuses to admit gay couples be denied the tax exempt status? What did the government say? Yeah, that's going to be an issue. This is going to be an issue, not from the IRS, but from local municipalities to take away sales tax and property tax exemptions from churches that exclude gay couples. You will see this, I think, in the next 5 years.
And churches, perhaps not immediately, but religious schools and social service organizations, nonprofits.
Yeah. I see a hand in the back.
Yeah, I had a question somewhat along those lines about refusal of to make wedding dresses, cakes, etc. I mean, a business can generally refuse to serve a customer just in general, but are they gonna be prosecuted in some way if they refuse on grounds of gay marriage?
Right, so there are exclusions from the general principle that businesses can refuse service. And under the Federal Civil Rights Act, and each state has its own, which defines different protected categories. You can't refuse service based on race, religion, sex, other categories. Some states, sexual orientation, others not. Some states, I know District of Columbia, for example, on the basis of political opinion. So in theory, a printer who's a Democrat can't refuse to print placards for Republicans. I don't know if there are cases like these brought, but not many Republicans in D.C., but anyhow. There have been cases like this, and so far, most state Supreme Courts have supported the challengers, that is, forcing the baker or the wedding vendors and so forth. Although there is, I think, a distinction between serving a gay clientele and working a gay marriage. And indeed, most of these, and most if not all of these cases, the Oregon bakers or the New Mexico wedding photographer, there are others, the upstate New York facility or so forth. They serve gay people. They're not like, if you're gay, go away. They just don't want to be involved in the wedding ceremony. And then you have the overlay of the State Religious Freedom Restoration Act. Is there no other way of accomplishing a compelling state goal? And here it seems to me, given that most wedding vendors, the overwhelming majority would be happy to work the gay wedding. In fact, they would gain more clients by saying, putting a rainbow flag in their window. It seems like there's really not a compelling state justification to make any particular one work them. But that's another area.
So the issue to make clear with the accommodation of these cases is an issue of speech and not exclusion, right?
Well, both.
Well,
Some of them, a caterer or a limousine service company, there's not really a speech issue there.
so the speech issue with a florist or a baker is that actually creating a bouquet of flowers for a wedding or designing a cake is an expressive act. These are acts that require thought, innovation, creativity. And we have a long-standing prohibition in this country against forcing people to speak where they don't want to. So I think the important avenue for these cases, first in terms of speech, and then secondary in terms of religious accommodation. So I have somewhere.
Do you have another question?
The last thing you said, it seemed to me could apply to race as well, because you said, oh, well, if they put a gay flag in the window, they'll get more business, so we don't need to specifically stop anyone from discriminating against the gays. And I think that's a really bad policy to say, because it won't hurt them as a whole, it's okay to let some people discriminate. I think that's...
In general, I think unless there's extenuating circumstances, I think business owners should be able to serve whomever they want for a good reason, bad reason, or no reason at all. The problem you get is when there is state involvement or monopoly power. So Jim Crow had both of those, state enforcement of segregation laws and monopoly. If you couldn't get served food at a particular place or stay at a hotel, you had nowhere to go for hundreds of miles around. That's obviously a problem. But in a situation where, in fact, the state is not forcing anyone to do anything, and there are over 100 wedding photographers in the Albuquerque area, there's no real reason to force this particular one to go against their beliefs or desires about how they want to run their business.
What I think is interesting, though, you have to remember in all of this stuff, the few cases that come up get all the headlines. But the vast majority of businesses, the vast majority of people, they have accepted the basic premise of if other people ought to be allowed to marry who they want. You have all the hubbub about the one clerk in East Texas, Ms. Davis, who's making an issue of it. But there's just no issue anywhere else in the
In
country.
Kentucky, which is a different issue because then she's a government actor, not
But it's like there's no issue really about anywhere else. And the vast majority of people who do flowers or cakes or whatever, they have no problem serving clientele, whatever. So it's to me the interesting thing is there's not the kind of really massive resistance that you saw during the Jim Crow era to attempts to try to stop segregation and stop racial discrimination. There just isn't that kind of massive. There are a few people who are hanging on to some bigoted ideas.
They're not
big. Whoa,
Yes, they
they're
are.
not big.
They really are bigoted ideas. They really are. But they're just a few. The point is, it's not really, society sort of, in a large respect, move on from that issue. And, that to me is the interesting thing, is how little sort of
So
Little social
Obama
response
apparently
was
was
really
big
bad.
until 2010, 2011.
It was
Obama was a big until
They were all pandering to what they perceived as the bigotry of the majority of the electorate. But that's the point. How much has changed? How much the overall perception of the American people have changed on the issue is that you don't have to pander to that now the way you did 10 years ago. That to me is the most interesting part of the whole thing.
But again, all of these cases that get publicity, it's about gay weddings. It's not about serving gays. I don't know about any case that's.
Yeah, that's true. Which again shows that on that issue, there's not a problem. Society has moved way past that. It's not like we're not serving blacks at restaurants the way we did in the 1950s. That's not happening.
All right, and on that happy note, I want to thank our panelists again for coming in. It's been a very fascinating event to do for the last 3 years, be a part of. So I just want to thank them. I know that we're rapidly losing people when everybody has to go to class, so I will say watch out for an email. I will put future events on there and let y'all know. If anybody's interested in playing kickball, by the way, let me know, please. We're trying to put a kickball together for charity, and all the profits go to the clinics here on campus, so that students can get funding and stuff like that. It's a good cause. If you're interested, come see me there. But other than that, go back to class.
Next year.